Welcome back to the deep dive. Today we are embarking on a really fascinating and absolutely crucial exploration.
We're diving into a major regional human rights system, the African Union System for the Protection of Human Rights.
It's a system, as we'll see, born from a pretty unique history on the continent.
Definitely. Facing distinct challenges and possessing some truly original features, things that really set it apart, in the global landscape of human rights protection.
Absolutely. And look, we're able to bring you this exploration today thanks to documents generously made available by the University of London.
That's right. And they're provided for educational purposes only, which is important to state.
Yes, hugely important. So we're incredibly grateful for their contribution to learning and helping us access this essential material.
And this deep dive, drawing specifically from the insights in those documents, is probably brought to you by Sinorbit Academy, Sri Lanka.
Yes, a big thank you to Sinorbit Academy. And, we know many of you listening might be studying this, perhaps preparing for exams in this area.
Yeah, definitely relevant for students.
So to all of you, we wish you the very best of luck. Think of this deep dive as kind of a targeted, comprehensive study session.
Exactly. Designed to cut through the complexity, helping you grasp the essential concepts, the pivotal cases, and the key details you absolutely need to remember.
Our mission today is pretty straightforward then. We're going to unpack the core of the African human rights system, following the comprehensive path laid out in our source material.
We'll trace its evolution from its origins, dissect its foundational treaty, the African Charter, explore the specific mechanisms it created.
Examine those crucial supplementary protocols dealing with specific groups, like women and children.
And walk through a really critical case study, one that reveals how the system operates in the real world, including its strengths and its limitations.
And we'll be highlighting those crucial facts, the important cases, and the key concepts you'll want firmly in your mind.
Definitely. Now, the African human rights system, it's actually the youngest of the major regional systems we've looked at.
And it operates within a particularly challenging environment, doesn't it?
Oh, absolutely. It faces significant issues like, pervasive conflict, poverty, complex governance structures. All these things have profoundly shaped its development and how it functions.
And as the source material compellingly argues, it offers a really insightful window into the cultural context of rights.
It does. You'll see a much stronger emphasis here on individual duties and collective or people's rights than you might find in, say, European or Inter-American systems.
And this difference isn't just theoretical, is it?
No, not at all. It's woven right into the fabric of the system's core document, the African Charter itself.
Okay, so where do we begin this journey? The foundations. Where do we start?
Well, we have to start right at the beginning.
Yeah.
With the Organization of African Unity, the OAU.
Ah, the OAU, established May 25th, 1963, right, in Addis Ababa.
That's the one. A very significant date for the continent.
And the source material makes it clear that at this stage, the OAU's focus was primarily external, focused on liberation.
Precisely. The main objectives were laser-focused on ending colonialism and dismantling apartheid across Africa. That was the defining political struggle, the unifying goal for the newly independent nations.
So it follows then that human rights within those independent African states weren't really the top priority at the start.
Not at first, no.
Yeah.
The OAU was incredibly active and successful in the anti-colonial movement, but it was widely criticized
For what?
for
Exactly.
largely ignoring human rights abuses happening inside the very states it championed.
And the source gives some really stark examples. Idi Amin in Uganda, Mobutu Sese Seko in Zaire, horrific situations.
Exactly. And what makes this particularly striking, as the source notes, is that these rulers actually served as OAU chairperson during their time in power.
Wow, that really underscores the point, doesn't it? The focus was on state sovereignty, liberation from external forces, not so much internal accountability back then.
But that criticism, that external pressure, it did eventually spur action. The source indicates that the drafting of the African Charter on Human and People's Rights began in 1979.
Which was notably around the time Amin was overthrown.
Right. And the charter then came into force in October 1986. This was a pivotal moment, a significant shift towards integrating human rights concerns into the organization's formal mandate.
And this evolution, this shift, it culminated in the transition from the OAU to the African Union, the AU?
Correct. The call for the AU came in 1999, leading to its formal establishment in July 2001, effectively replacing the OAU.
And the AU's Constitutive Act. It lays out a much broader set of objectives compared to the old OAU charter, doesn't it?
Much broader, much more ambitious. It's about achieving greater unity and solidarity, preserving sovereignty, yes, but also pushing for political and socioeconomic integration.
Developing common positions, promoting peace, security, stability, fostering democracy, good governance. It sounds like a much wider, more forward-looking mandate.
It is, aimed at the continent's future development. And here's a crucial point. The AU's Constitutive Act includes an explicit commitment to human rights.
Okay, so it's written right in there.
Yes. It states that the AU is tasked with promoting and protecting human rights in accordance with the African Charter on Human and People's Rights and other relevant human rights instruments. This really solidifies the place of human rights as a core function.
The Act still upholds principles like sovereign equality, existing borders, peaceful dispute resolution. But there's one principle that really stands out. The source identifies it as a key development, a big departure from the OAU's strict non-interference.
Ah, yes, you mean the intervention principle.
Exactly. This is where it gets really interesting and controversial, too, I imagine.
It is controversial. It's the principle giving the union the right to intervene in a member state, but, and this is key, only in response to grave circumstances.
And those are specifically defined.
Yes, war crimes, genocide, and crimes against humanity. And even then, only pursuant to a decision of the AU Assembly.
So it's a high bar, but it suggests the AU is willing, at least in principle, to override state sovereignty in the face of mass atrocities. A stark contrast to the OAU era.
A very stark contrast, where internal issues were often shielded by that non-interference norm.
This broader vision was also linked to initiatives like NEPAD, the New Partnership for Africa's Development.
Right. NEPAD grew out of an OAU initiative focusing heavily on social and economic development, tackling poverty, underdevelopment, marginalization.
And NEPAD also brings in governance and human rights concerns.
It does, significantly. It incorporates concerns about good governance and human rights, building directly on the principles enshrined in the AU's Constitutive Act.
Okay. So if you're looking at the history, you see this really clear and important evolution.
Definitely. From an organization focused mainly on liberation from external powers,
to one with expansive goals for integration, an explicit mandate for protecting human rights internally.
and even that debated principle allowing intervention in the most extreme circumstances.
Understanding this transition from OAU to AU is fundamental then, isn't it? For grasping the context and priorities that shaped the whole system.
Absolutely. And this historical context directly led to the system's cornerstone treaty, the African Charter on Human and People's Rights.
Right. Let's talk about that absolutely central document, the African Charter on Human and People's Rights, the ACHPR.
Okay. So this charter, adopted in 1981, entering force in 86, it remains the foundational treaty for Africa-specific human rights protection.
And it explicitly builds on the earlier OAU objectives.
It does, and it anchors itself on core principles like freedom, equality, justice, dignity. The source connects these directly to the goals of eradicating colonialism, striving for a better life, promoting international cooperation.
It also references the UN Charter and the Universal Declaration of Human Rights quite a bit.
Yes, throughout. So it positions itself within the broader international human rights framework. But at the same time, it really emphasizes its own unique character.
And that unique character is crucial. The source stresses its essentially African nature, describing the Charter as drawing on historical tradition and the values of African civilization.
And that's not just rhetoric. It directly influences the distinctive features we need to discuss, particularly this concept of people's rights.
Okay, let's start there. People's rights. This is perhaps the most notable feature, setting the ACHPR apart, wouldn't you say?
I would. It's fundamental to the Charter's philosophy. As the source quotes, the underlying belief is that the reality and respect of people's rights should necessarily guarantee human rights.
So it sees individual rights as inherently linked to the rights of communities, of groups.
Exactly. This concept is primarily articulated in Articles 19 through 24. We should probably walk through a few of the key ones.
Good idea. Article 19 seems foundational. All peoples shall be equal. Nothing shall justify the domination of a people by another. That sounds like it directly echoes the anti-colonial struggle.
It absolutely does. Framing equality specifically in terms of preventing domination, then Article 20 addresses the right to existence and self-determination.
Self-determination. The right to choose political status, pursue economic development.
Yes, and the source highlights how this article is explicitly connected to the liberation struggle. It says colonized or oppressed peoples have the right to free themselves, by any means recognized internationally, and a right to assistance in that struggle.
Wow, that's quite explicit. Linking equality, self-determination, and the anti-domination fight.
That Article 21 is vital because it connects this to resources. It grants peoples the right to freely dispose of their wealth and natural resources in their exclusive interest.
And if they've been dispossessed.
They have the right to lawful recovery and adequate compensation. The source points out this links to international economic cooperation and places a specific state duty on governments to eliminate foreign economic exploitation.
Particularly by international monopolies.
Yes, for the benefit of the people. This really underscores the communitarian underpinnings framing resource control as a collective right essential for the people's well-being. You really need to remember Article 21 for economic rights tied to resources.
Okay, Article 21, resources, people's rights. Got it. What about Article 22?
Article 22 builds on this. It guarantees the right to economic, social, and cultural development for all peoples, with regard to their freedom and identity. And again, it places a state duty, individually and collectively, to ensure this right is exercised.
The source sees this as an extension of the anti-colonial struggle against underdevelopment, linking resources and development.
Exactly. Linking Article 21 and Article 22, then Article 23, speaks to the right to national and international peace and security.
Governed by UN and OAU principles.
Right. But there's a significant qualification in 23, reflecting the political realities of the time. Individuals granted asylum shouldn't engage in subversive activities, and territories shouldn't be used as bases for subversion or terrorism.
Ah, reflecting concerns about instability in newly independent states.
Precisely.
Yeah.
And finally, Article 24 grants all peoples the right to a general satisfactory environment favorable to their development.
So that's the environmental rights piece, framed as a collective right.
Yes. Remember Article 24 for environmental rights?
Now, the source offers some important insight into understanding peoples here. It's not just nations in the traditional sense.
No, it's broader. It encompasses communities, groups, minorities as well. It frames these rights as part of the political struggle for change development, cultural rights, linguistic identity. They're seen as both political and moral claims.
Often advanced through political action leading to legal change.
That's the idea. And this concept of people's rights naturally connects to the broader global debate about third-generation rights.
Right, the source touches on that debate. Some argue these are essential extensions, reinforcing existing rights.
Preventing the concept of rights from becoming static. While the counter-argument is that these collective rights might dilute or undermine foundational individual rights.
Turning them into aspirational political claims rather than justiciable legal ones.
That's the concern raised. The source notes the debate often circles back to Article 28 of the UDHR about the right to a social and international order where rights can be fully realized.
Okay, that gives a good sense of people's rights. What about the second major distinctive feature? The emphasis on duties.
Yes, this one perhaps stands out even more strongly for those used to purely individual rights frameworks. The Charter explicitly states, the enjoyment of rights and freedoms implies the performance of duties.
The source explains this reflects a philosophy where rights correlate with duties and the individual is seen as part of a community.
Exactly. Individual rights are qualified by community membership. This is articulated in Articles 27, 28, and most extensively, Article 29.
So Article 27 establishes the foundation, duties towards family, society, state, communities, international community.
Right. And exercising rights with due regard to others' rights, collective security, morality, common interest. Remember Article 27 as the basis for duties.
Article 28 is about mutual respect and tolerance.
Yes, the duty to respect fellow beings without discrimination. But Article 29 provides the most detailed list.
And these duties are owed to family, nation, and significantly explicitly to African cultural values.
That's a key point. The source emphasizes that direct link between individual duties and traditional culture.
Let's look at some specifics in Article 29. Duty to preserve family cohesion, respect parents' elders.
Assist parents in need, serve the national community with your abilities, don't compromise state security.
Preserve social and national solidarity, preserve national independence, contribute to defense, work, pay taxes.
And, very importantly, the duty to preserve and strengthen positive African cultural values, tolerance, dialogue, consultation, and contribute to moral well-being.
And contribute to promoting African unity. That's a really comprehensive, culturally rooted list.
It is. The source suggests the justification is staked on this originality of emphasis, drawing directly from traditional African culture, claiming these values are given legal form here.
But the source also points to a potential tension. Does this duty to the state limit individual rights, especially if the state is abusive?
That's the problematic question raised. Can preserving cultural values sometimes mean opposing an oppressive state? It highlights a delicate balance.
So, assessing these distinctive features, people's rights and duties, the source suggests it's complex, tied to enforcement and context.
Yes, the impact depends heavily on the effectiveness of the enforcement mechanisms, which leads us to how the Charter was initially set up for oversight.
Right. And the initial setup was quite different from other systems, no court at first.
No court initially, correct. Only the African Commission on Human and People's Rights.
Why was that?
Several reasons given in the source. Comparable systems relied heavily on commissions then. Court jurisdiction wasn't always compulsory elsewhere. But crucially, the political reality. Many African states in the early 80s were non-democracies, unlikely to agree to a strong, binding court.
So the African Commission on Human and People's Rights, established by Article 30, became the main body, 11 members serving independently.
Yes, in their personal capacity, not as state representatives. That independence is important.
And their main functions are in Article 45, promotion, protection, and interpretation of the Charter.
Exactly. Remember, Article 45 is crucial for the Commission's mandate.
The promotional activities sound quite broad. Collecting documents, studies, organizing seminars, disseminating info, encouraging national institutions.
Yes, and giving views and recommendations to governments. They've engaged extensively with NGOs, granted observer status, appointed special rapporteurs on specific issues.
Like women's rights, freedom of expression.
Right, and established working groups, often bringing in external experts. The source suggests this promotional work has been extensive and quite significant.
Okay, then the protection activities,
Yeah.
preventing state violations. The main mechanism here is the communication procedure.
Yes, and this is vital to understand. It's a system allowing any individual, NGO, or group to petition the Commission about alleged abuses.
That sounds quite broad standing for complainants, wider than some other systems.
It is notably broad. There's also an interstate complaints system, though it's rarely used.
But for communication to be considered, it needs to meet admissibility criteria under Article 56.
Correct. And the most significant one in practice is exhausting local remedies. You have to try the domestic courts first, unless it's obviously futile or taking too long.
The subsidiarity principle. The Commission is a last resort.
Precisely. Remember, Article 56 is central to admissibility.
If a communication is admissible, what happens?
The Commission informs the state, invites observations, then, under Article 52, it must try to reach an amicable solution based on respect for the Charter rights.
And if that fails?
If no settlement, the Commission determines if there's a violation. If yes, its power is to make recommendations to the state and the AU Assembly.
Recommendations, not binding judgments.
That's the key limitation the source underscores. Recommendation.
Can they do anything in emergencies?
They can request provisional measures, asking the state to hold off on actions if, say, someone's life is in danger. But supervising implementation of their recommendations is a major challenge.
How so?
The source notes the Commission lacks formal procedures for follow-up. It relies on correspondence. Compliance really depends on state goodwill, which is often lacking. It's identified as a major structural weakness.
Can they do on-site visits?
Yes, fact-finding missions to investigate abuses, engage with governments and civil society, either on their own initiative for widespread issues or related to specific communications.
And there's state reporting under Article 62. States report every 2 years on implementation.
Yes, though the source calls these reports patchy. But importantly, individuals and groups can submit shadow reports, giving alternative views. The Commission reviews these, dialogues with states, makes recommendations. Article 62 is the basis for state reporting.
So the Commission is central under the original charter, wide mandates, broad communication procedure, but enforcement of its recommendations is a key challenge.
Exactly. And this limitation, among other factors, eventually led to the push for a court.
Which brings us neatly to Section 3, the institutional evolution towards a court and the challenges that process faced.
Right. So by 1994, the AU Assembly felt it was time to consider establishing a court to complement the Commission.
A protocol was drafted in 1998, but it took a while to come into force.
6 years. It finally entered into force in 2004. But even then, ratification was slow. The source notes by late 2016, only 24 states had ratified the protocol.
Only 24. That low number immediately signals a challenge in state commitment, doesn't it?
It certainly does. The court itself is located in Arusha, Tanzania.
Which is becoming a hub for international courts in Africa.
Yes. However, the source's assessment of the court's experience, at least up to the end of 2018, is, well, pretty blunt.
How so?
It says the court's experience has, not to date, been a productive one. Out of over 40 applications considered, not one had produced any useful or significant jurisprudence.
Not one. Why such a lack of dynamism?
The source points partly to AU decisions to consolidate institutions, which created significant institutional uncertainty.
Uncertainty about the court's future.
Exactly. There's a plan to merge the African Court on Human and People's Rights with the separate AU Court of Justice to create a single African Court of Justice and Human Rights.
Okay, a merger plan. Did that happen?
Well, a protocol for this merged court was adopted in 2008, but the source points out that by late 2018, very few states had actually ratified that 2008 protocol.
So the merger stalled.
And adding more confusion, another protocol was adopted in 2014, amending the 2008 protocol. But that 2014 protocol isn't in force either.
Wow, that sounds incredibly messy. No wonder there's uncertainty.
It creates a very complex and unclear picture regarding the judicial pillar. This persistent institutional uncertainty, combined with low state ratification, has clearly hampered the Human Rights Court's ability to really get going and develop jurisprudence.
The source does mention some communications from the commission can be referred to the court.
Yes, suggesting some linkage. But the overall picture painted is one of a court facing significant roadblocks.
So a key takeaway here for anyone studying this, a court exists, representing a step towards stronger judicial enforcement. But its practical effectiveness has been severely limited by ratification issues and this ongoing complex institutional uncertainty, potential that's struggling to realize it.
Precisely. And to really understand how the Charter and its mechanisms function, their potential and their limitations, there's one case study that's absolutely indispensable.
Ah, you must mean the Ken Saro-Wiwa case.
Exactly. The Ken Saro-Wiwa case. It's critical because it illustrates how the IPHR and the Commission operate in practice, the kinds of issues they tackle, and the significant challenges in getting compliance and effective remedies. The source rightly emphasizes seeing it in the broader context of Nigeria's political history. Remember Ken Saro-Wiwa and the Ogoni. This is a vital case study.
Okay, let's get that context on Nigeria first, as the source details. Post-independence history, alternating democracy and military rule.
Yes, military coups were commonplace. The source mentions the annulled 1993 election, General Abacha's takeover later that year, dissolving democratic institutions.
But a crucial shift happened after Abacha's death in '98.
Right. General Abubakar took over, started releasing political prisoners, commuting death sentences, moving towards restoring rights. Nigeria returned to democratic rule with Obasanjo's election in '99.
Re-elected in 2003, and the source notes the first peaceful democratic power transfer in 2007, with more since. So a significant change post-Abacha.
Definitely. The source also highlights Nigeria's complexity. Huge population, hundreds of ethnic groups and languages, two major religions. This diversity has sadly contributed to periods of serious intercommunal violence.
And the human rights situation before 1998 during the Saro-Wiwa events. The source paints a bleak picture based on UN reports.
Exceptionally bleak. Widespread problems, arbitrary arrest, summary killings, torture, restrictions on expression and association, discrimination, executive control over the judiciary, and ineffective judiciary. UN special rapporteurs confirmed this grim reality.
It's within that context the Ken Saro-Wiwa case unfolded. He was a prominent writer and activist.
Yes, and along with 8 others, they became known as the Ogoni 8. Their activism focused on protesting the marginalization of the Ogoni ethnic group in the oil-rich Delta region.
And the accusations against the government were severe. Extracting oil with little regard for environmental damage or compensation. Abuses by security forces.
Exactly. Widespread allegations. The trigger event for the trial was rioting in May 1994, where 4 Ogoni leaders were murdered. Saro-Wiwa and the others were arrested and brought before a civil disturbances special tribunal.
An ad hoc tribunal created just for this case.
Yes, and the UN Special Rapporteur identified numerous fundamental due process violations. It was alleged the rioting itself resulted from government agents stirring dissent. Crucially, the tribunal was constituted in contravention of due process.
How so?
The judges, including an army officer, were appointed by the executive, a direct violation of the principle of an impartial court.
The source explicitly calls this a contravention of the African Charter, Articles 7 and 26, and the ICCPR.
Yes, Article 7 on due process, Article 26 on judicial independence, and ICCPR Article 14.1. A constitutional challenge was reportedly never even heard.
Other breaches, too, excluding defense evidence, harassing defense lawyers.
Yes, and the source notes this trial was seen as part of a pattern of purges against opponents under Abacha, mentioning other trials, secret tribunals, death sentences around that time.
The outcome was devastating. Sarawiwa and the others sentenced to death in October 95, executed just a month later in November 95, despite international outcry.
A truly shocking outcome. Remember their names and this tragic result.
So the African Commission got involved after the executions when a petition was filed.
Correct. In a 1999 decision, the commission found Nigeria had breached Article 5, ill treatment during imprisonment, failure to respect dignity, supported by breaches of Article 4, inviolability.
They also found breaches of Article 6, liberty, and 7, due process, and Article 10, free association.
Yes, but a later decision in 2001 was far more comprehensive. This is where the case becomes particularly insightful for understanding the breadth of the IPHR.
How so? What else did they find?
The Commission found breaches of numerous other articles, including the people's rights ones, Article 21, on resources. They said, while the government could produce oil, the exploitation had to be equitable and in the interest of the people.
And a right to compensation for environmental degradation.
Yes. And significantly, they stressed the state duty to eliminate foreign economic exploitation, mentioning corporations like the Shell Consortium. Crucially, the Commission stated the Nigerian state had a duty to protect its citizens against harmful acts by private parties like Shell.
That's a very important point about state responsibility for corporate impacts.
Absolutely. They also found breaches of Article 24, Environment, and Article 16, Health, citing the state's duties to safeguard health and preserve a favorable environment.
My. Because the government participated in pollution and failed to protect people and the environment from Shell's activities. Failed to assess the damage.
That was the finding. They also accepted arguments based on Article 14, property, and even an inferred right to shelter linked to the destruction of villages.
And notably, they accepted an argument about the right to food being infringed, even though it's not explicit in the charter.
Right. The source highlights they implied it by reading Article 1, Life, Article 16, Health, and Article 22, Development, together. This shows the Commission using its interpretive role under Article 45 to really develop and expand the understanding of rights.
Okay, so what was the actual impact of these commission decisions?
Well, the source notes some criticism exists, but it's seen as having significant symbolic importance. A crucial intervention, part of the broader political development towards democracy in Africa.
The decision came just as civilian rule was returning, right? So maybe signaling a renewed commitment.
Potentially. The Nigerian government hadn't cooperated much regarding domestic remedies earlier, but post-Abacha they did acknowledge ongoing abuses by oil companies.
But the source says the improvements in Nigeria's human rights situation since then aren't primarily due to the Commission's decision.
Correct. It's seen as part of a process, a moral and legal vindication for the Ogoni people, contributing to reconciliation. But in terms of actual remedies,
What about compensation, for example?
the source says the decision merely reminded the government of the issues. It leaves a great deal to be desired in terms of compensation. Remedies ultimately remained within Nigeria's sovereign competence.
So that highlights the limitation, again, recommendations, not binding orders for specific remedies.
Exactly. It powerfully illustrates that limitation.
So the Sarawiwa case study is absolutely fundamental. It shows the ACHPR's comprehensive rights catalog in action. People's rights, environment, health, even implied rights like food. It shows the Commission interpreting and applying these robustly.
But it also starkly reveals the challenges of enforcement and the limited nature of remedies when the main mechanism can only issue non-binding recommendations. Understanding Ken Saro-Wiwa and the Ogoni 8 is critical for appreciating both the achievements and the persistent weaknesses. A key case study to have firmly in mind.
Okay. Beyond the foundational charter, the system has continued to evolve, adopting specific protocols for vulnerable groups.
Yes, Section 5 focuses on two crucial ones, women and children. Let's start with the Protocol on the Rights of Women in Africa, the Maputo Protocol.
In force since 2005, it places women's rights in the context of development.
Exactly. The need arose because the original ACHPR's protection for women was seen as inadequate. Article 18 was limited. No specifics on consent or equality in marriage, and traditional harmful practices were a major concern.
So even though many states ratified CEDAW, there was a feeling something more Africa-specific was needed.
Yes, reflecting the context and cultural nuances more explicitly. The protocol frames itself as a development of the Charter, linking back to IPHR Articles 2, 18, 60, and 61, and aligning with AU and EPAD goals on gender equality.
Let's look at some main provisions because the source indicates they're extensive. Article 2 on combating discrimination. It requires specific state actions.
Very specific. Incorporate equality in law. Enact laws prohibiting all harmful practices. Integrate gender perspective in policies. Take positive action. Support women's initiatives. Note the detail there.
Article 3 on dignity, Article 4 on life, integrity, security, and crucially, prohibiting all forms of violence against women, including unwanted sex, private or public.
Yes. And eradicating legitimizing beliefs, preventing trafficking. It's a remarkably strong provision.
And Article 5 specifically targets harmful practices, like FGM.
Directly. Prohibiting all harmful practices contrary to international standards. A key article.
Article 6 on marriage sounds vital too. Equal rights, free full consent, minimum age 18.
Encouraging monogamy, protecting in polygamy, registered marriage, choice of residence, retaining maiden name, nationality rights, joint responsibility for children, managing a property. Article 6 provides crucial, detailed specifics.
Article 7 on separation, divorce, equal rights, judicial order needed, best interests of child paramount, equitable property sharing.
Correct. Then Article 8 on access to justice, 9 on political participation, 10 on peace and asylum seekers. Article 11 is notable regarding armed conflicts.
Ensuring no child, especially girls under 18, takes part in hostilities or is recruited.
Yes. Article 12 covers education. Article 13 on economic and social welfare is exceptionally comprehensive.
Equal opportunities, equal pay, but also detailed state duties. Protection for informal sector workers, minimum work age, recognizing economic value of work in the home, paid maternity leave, equal taxation.
Exactly. Article 13 is very detailed and progressive on economic rights.
And Article 14 on health and reproductive rights, another groundbreaking one.
Absolutely. Control fertility, decide number spacing of children, contraception, protection from IVAs, right to know health status.
But the state duties are key here. Provide services and, remarkably, authorize medical abortion in specific cases. Rape, incest, endangerment of health or life.
Yes. Article 14 contains some of the most explicit and advanced reproductive rights provisions in any regional treaty.
Articles 15-19 cover food, housing, culture, environment, development. And then Articles 20-21 specifically on widows' rights.
Yes, ensuring their human rights. Specifics include no inhuman treatment, automatic guardianship of children, unless against best interests, right to remarry, equitable share in inheritance, right to live in matrimonial house, equal inheritance from parents, addressing specific vulnerabilities.
Articles 22-24 cover special protection for elderly, disabled, women in distress, including poor women, heads of families, pregnant nursing women in detention.
Right. Very specific protections. Enforcement, Arts 25-26, relies mainly on state responsibility and state reporting under IPHR Article 62.
So the assessment: ambitious, fills gaps, takes forward global principles, but effectiveness depends on state will, and it lacks its own strong enforcement system.
That's the assessment in the source. Relies on the general IPHR mechanisms with their known limitations.
Okay, now the second key protocol, the African Charter on the Rights and Welfare of the Child, the ACRWC.
Adopted in 1990, right after the UN CRC. The source explains African states felt underrepresented in the CRC drafting, wanted something reflecting African cultural religious perspectives and specific continental problems.
Like children under apartheid, harmful practices against girls, displaced refugee children. Concerned CRC didn't fully reflect African family norms.
Exactly. But it was clearly influenced by CRC principles. Non-discrimination, best interests, survival development, evolving capacities.
Article 1 immediately places an obligation on states to discourage any custom, tradition, cultural, or religious practice inconsistent with the Charter.
A strong start, directly confronting harmful practices. Article 3 is a comprehensive non-discrimination clause.
Article 4 is the central principle. Best interests of the child shall be the primary consideration, and the right to be heard.
Yes, views considered according to age and maturity. Article 4 is foundational.
Article 5 on survival development, inherent right to life, and a very strong protection. No death sentence for crimes committed by children.
A very strong protection indeed. Article 6 covers name, nationality, registration. Articles 7, 8, 10, adapt expression, association, privacy rights for children.
Article 9 on thought, conscience, religion, parental guidance, but regarding evolving capacities and best interests.
Yes. Article 11 directs education towards responsibility, tolerance, respect. Article 15 protects against child labor.
Article 16 on abuse, torture, state measures to protect from various forms of harm, specifically while in care.
Right. Notes that specific context. Articles 18 and 19 focus on family protection and the parent-child relationship, right to reside with parents unless separation is in best interests.
Article 20 on parental responsibilities, best interests, basic concerns, secure living conditions, and importantly, domestic discipline administered with humanity and dignity.
That explicit reference to dignity and discipline is notable. Article 21 directly addresses harmful social-cultural practices again.
Mandating measures to eliminate practices affecting welfare, dignity, development, specifically prohibiting child marriage betrothal, setting minimum age 18, compulsory marriage registration.
Very important. Mirroring the women's protocol, but adding child marriage specifics. Article 23 covers refugee children's protection and assistance.
Article 25 on separation from parents adds a unique cultural consideration. When considering alternative care, due regard to continuity in child's ethnic, religious, cultural, linguistic background.
Yes, adding that identity dimension to best interests in the African context. Article 26 protects against apartheid. Article 27 is very detailed against sexual exploitation.
Preventing inducement, coercion, use in prostitution, pornography, very specific prohibition.
Extremely specific. And finally, the unique feature. Article 31, the responsibility of the child, linking back to the IPHR duties.
Responsibilities to family, society, state, communities, subject to ageability.
Yes. Duties like family cohesion, respecting parents' elders, assisting them, serving national community, solidarity, independence, and again, preserving, strengthening positive African cultural values, tolerance, dialogue, consultation, moral well-being, contributing to African unity, explicit duties on children.
Supervision is by the African Committee of Experts on the Rights and Welfare of the Child.
Correct. Established by Article 32. Their mandate, Art 42, is comprehensive. Promotion, protection, collecting info, assessing situations, events, encouraging institutions, giving views, formulating principles, cooperation, and specific mandates to monitor implementation and interpret the Charter.
States report every 2 years, Art 43, and communications, Art 44, can come from a very broad range. Any person, group, NGO, state, UN.
Yes, the source notes this broader standing compared to the initial IPHR commission procedure. The committee can also investigate Art 45 and reports to the AU Assembly.
So these two protocols, Maputo and ACRWC, are vital expansions, demonstrating commitment to women and children with incredibly detailed provisions on harmful practices, reproductive health, child marriage, even child duties.
Absolutely. Strong norms, but effectiveness, again, tied to state implementation and the monitoring mechanisms, which rely on reporting and recommendations without binding court enforcement. Remember the unique provisions, harmful practices, Maputo Art 5, ACRWC Art 21, reproductive rights, Maputo Art 14, child duties, ACRWC Art 31, they are key points.
Okay, finally, let's tackle a persistent major challenge: the protection of refugees in Africa.
Right. Refugees are protected under international law, the 1951 Geneva Convention, the Covenants, ACHPR. The standard definition involves fleeing due to a well-founded fear of persecution for specific reasons.
And the source makes that key distinction: refugee, cross-border versus internally displaced person, IDP, within state. Fundamental difference.
Yes. Relevant ACHPR rights for refugees include life, Art 4, no torture, Art 5, liberty, Art 6, due process, Art 7, family reunion aspects, Art 18, and crucially, movement residence in seeking asylum, Art 12.
Historically, the source notes an open-door policy was common in the 60s, 90s, displacement from conflicts in Rwanda, Mozambique.
Yes, neighbors often provided asylum. But a shift occurred from the early 90s. Brutal conflicts in Sierra Leone, Liberia, Congos, CAR, Angola, Rwanda led to massive displacement.
Overwhelming host countries, leading to closed borders, forced repatriations.
Exactly. Host countries face huge domestic concerns. Security, strain on resources, environment, often limited international burden sharing.
It was within this context, predating the biggest crises but anticipating dynamics, that the OAU Convention governing the specific aspects of refugee problems in Africa was adopted in 1974.
Correct. Founded on a humanitarian approach, but also reflecting OAU political concerns, distinguishing peaceful refugees from subversives. It references the UN framework, 42 states ratified by late 2016.
Article 1 defines refugee, and this is a crucial difference from the UN definition.
Absolutely crucial. Article 1.1 includes the 1951 definition, fear of persecution. But Article 1.2 provides the broader African definition,
which includes people compelled to leave due to external aggression, occupation, foreign domination, or events seriously disturbing public order.
Exactly. This captures mass displacement from conflict and upheaval beyond just individualized persecution, a key adaptation to African realities.
There are exclusion clauses for war criminals, too.
Yes, in Art 1.5. Article 2 addresses asylum. States use best endeavors to receive settle. Granting asylum is peaceful humanitarian, not unfriendly. Crucially, it includes non-refoulement, no return if life liberty threatened. Also mentions burden sharing, temporary residence, settlement away from borders for security. Article 2 holds core protections.
Article 3 brings back that concern about subversion. Refugees must conform to laws and abstain from any subversive activities against any member state. States must prohibit refugees using territory for attacks.
Yes, that duty reflects the political context of the time. Article 4 ensures non-discrimination. Article 5 prohibits involuntary repatriation with voluntary return provisions. Articles 6 and 7 cover travel documents in cooperation with the OAU-AU.
So what's the assessment? The source says, on paper, one of the most progressive protection regimes.
Yes, but the reality is often starkly different. Endless human rights hurdles, including forced return, discrimination, arbitrary detention, restricted rights, economic deprivation. A significant gap between theory and reality.
And a major weakness identified is the absence of any meaningful supervision system for this convention. No dedicated court or treaty body.
Correct. General mechanisms like the IPHR Commission can be used as complementary means, but it's not a dedicated enforcement system for the Refugee Convention itself.
Addressing the crisis requires more than law, a political economic agenda, tackling root causes, arms trade, promoting democracy, development.
That's the argument. And critically, the need for international burden sharing to help host countries manage the impacts.
The source concludes the convention was an innovation with its broader definition, but the scale of the problem needs coordinated policy, and it's unclear if the political will exists.
Yes, citing scholars who reinforce these challenges.
So, key things to remember. The broader definition, Art 1-2, and the duty regarding subversive activities, Art 3. Progressive norms, but huge practical challenges, and no dedicated enforcement mechanism. Legal frameworks need political and economic action alongside.
Phew. We have certainly covered a huge amount of ground in this deep dive.
We really have. We traced the evolution from OAU to AU, the expanded mandate, the intervention principle. We dug into the foundational IPHR, its unique people's rights and duties, the Commission's role and limitations.
Looked at the vital supplementary protocols, Maputo for women, ACRWC for children, highlighting their detailed protections on harmful practices, reproductive health, child marriage, even child duties.
Examine the refugee challenge, the OAU Convention's broader definition, but also the stark implementation gaps and lack of specific enforcement.
And that critical Ken Saro-Wiwa case study, showing the system in action, the Commission's interpretive power, but also the struggle for remedies and compliance.
It's clear, isn't it? The African system has strong, ambitious norms, deeply rooted in African traditions and values, but it operates in a tough environment, facing significant implementation and enforcement issues, especially compared to regions with binding courts.
Definitely. So maybe a final thought for you to reflect on, especially if you're studying this. Consider how this African system's emphasis on communal duties and collective rights contrasts with more individualistic approaches elsewhere.
What might different systems learn from each other about balancing individual freedoms and societal responsibilities, protecting groups, addressing historical injustices?
And maybe the toughest question: how can even the best legal frameworks become truly effective when facing deep political instability and economic hardship? These are ongoing global challenges, really.
Absolutely. Questions that continue to shape human rights protection everywhere.
Indeed. Well, a final big thank you again to the University of London for making these valuable documents available for educational purposes.
And our thanks again to Sinorbit Academy, Sri Lanka, for bringing you this deep dive.
And once more, really, the very best of luck with your exams. We truly hope this deep dive has given you a clear, detailed, helpful overview, equipping you with what you need.
Keep digging deeper.
We'll see you on the next deep dive.